Are there further amendments to H.R. 115?
I have an amendment at the desk.
The clerk will report the amendment of the gentleman from Louisiana.
Amendment to H.R. 115 offered by Mr.
Chairman.
Richmond.
I would insist on a point of order.
A point of order is reserved, and the clerk will report the amendment.
Amendment to H.R. 115 offered by Mr. Richmond of Louisiana. Add at the end of the bill
Without
the
objection,
following.
the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment would simply direct the Department of Justice to conduct a study on racial disparities, as well as disparities based on sexual orientation, religion, and gender identification in the implementation of the death penalty in the United States, and develop recommendations to mitigate these disparities. Any discussion of the death penalty must include the recognition that capital punishment in the United States has not been administered equally. In a 1990 study, the GAO found a pattern of evidence indicating racial disparities in the charging, sentencing, and imposition of the death penalty. African American defendants are significantly more likely to receive the death penalty than white defendants. According to the NAACP, whites make up 46% of murder victims, but 76% of victims in death penalty cases since 1976. African Americans make up 50% of the murder victims, but only 15% of the victims in death penalty cases since 1976. Though these studies are revealing, it is far past time that the Department of Justice conduct a review of these disparities and develop a strategy to ensure equal justice under the law, regardless of race, ethnicity, religion, gender, or sexual orientation. And for that, I would ask that my colleagues support the amendment, but I'd also, Mr. Chairman, if I could inquire, because we went straight into amendments, when will we have a chance to strike the last word and speak on the bill as a whole?
It's appropriate to do that at any time during the markup.
Okay. Well, I would insist on this amendment, and I would just say, Mr. Chairman, without arguing whether we should keep the death penalty or not, if we're going to have the death penalty, we need to make sure that it is colorblind and that it does not discriminate, and that we at least owe it to the American people to make sure that they have confidence in the justice system and that justice is colorblind. So for that, I would urge my colleagues to support the amendment.
Chair, thanks, gentlemen. The gentleman from Ohio, does he insist on his point of order?
Yes, I do insist on my point of order. I would once again note that H.R. 115 is very narrow legislation. It amends 18 U.S.C. Section 3592C to add the killing or targeting of a state or local law enforcement officer as an aggravating factor for a jury to determine during the sentencing phase of the trial when the jury is determining whether a sentence of death is justified. And this amendment goes beyond the subject matter and therefore is not germane.
Does the gentleman from Louisiana wish to address the issue of the point of order raised by the gentleman from Ohio?
Yes.
Gentleman is recognized.
The GAO found a pattern of evidence indicating racial disparities in the charging, sentences, and imposition of the death penalty. We are expanding the reasons and aggravating factors to apply the death penalty, so we are expanding the potential use of the death penalty, which GAO says is discriminatory. So for us to add in a section that required the Justice Department to review and come up with a conclusion of whether there are disparities, whether it's discriminatory, and how do we alleviate that, I think is very germane. We're going to increase the use of the death penalty that we know is already discriminatory. But we don't want the Justice Department to look at those factors. I think it's very appropriate and it's germane if we are expanding the use of the death penalty. GAO has already said it's discriminatory, and now we're just asking that since we're expanding it, give us the full information on the discriminatory effects of the death penalty. I think it's very appropriate, and I think it's very germane.
I'd like to strike the last word.
The gentleman from Louisiana can yield to the gentlewoman only on the issue of the germaneness of his amendment if he chooses to do so.
I will yield a minute to the gentlelady from Texas.
Let me rise to support the gentleman's amendment, it is obvious that this is a narrowly drawn bill. That is the basis of the opposition and the question of germaneness, but the chair has the ability to waive the point of order, recognizing that the gentleman's amendment is a crucial amendment. It is long documented that the burden of death penalty falls in particular on the African-American community, though the question of the gentleman's amendment is to raise issues of race, ethnicity, or national origin, gender identity, sexual orientation, religious identity, or affiliation. I think that if we are a committee of justice, in this instance criminal justice, this amendment is a fair amendment, an unbiased amendment to add to a bill that is moving and adding another factor to the death penalty. With that, I yield back to the gentleman.
I would thank the lady, gentlelady from Texas, and now yield to Mr. Raskin.
Thank you very much. I just want to speak to the germaneness of the gentleman from Louisiana's amendment. The Supreme Court, in a decision called Mcclewsky versus Kemp, which was a case dealing with the killing of a police officer, a white police officer, by an African-American defendant, found that there was a systemic pattern of racial bias within the death penalty. They found it was 4 times more likely for a defendant to receive the death penalty if his or her victim were white than if his or her victim were African American. And this was especially pronounced in the kind of case that would be affected precisely by this legislation, where there's the killing of a police officer. Nonetheless, the Supreme Court said this was not a matter for the courts to deal with as a matter of equal protection. It was a matter for Congress to deal with in legislation. So it's hard to think of anything more germane than the amendment offered by the gentleman from Louisiana, because he's basically accepting the invitation of the Supreme Court and saying it's our responsibility to make sure that in the proliferation of aggravating factors for the death penalty, especially those dealing with the killing of police officers, that there's no racial bias or other kinds of bias that infiltrate the process. So I think this is clearly relevant, it's clearly material, and it's clearly germane. I yield back to the gentleman.
The gentleman yield back.
I yield back the balance of my time.
The chair thanks the gentleman and is prepared to rule on the point of order. The chair would note that there is work ongoing in this committee, led by the ranking member, the gentleman from Michigan, on the gathering of information regarding various types of crimes as a part of our overall criminal justice reform effort, and that will continue, and I am in hopes that it will result in some legislation that can be passed through the committee in a bipartisan fashion. However, with regard to the amendment offered, it was correctly noted that this is a narrowly drawn bill, and it is the opinion of the chair that the amendment is not germane. Are there further amendments to H.R. 115?
Yes, Mr. Chair. I have an amendment at the desk.
The clerk will report the amendment.
Amendment
Reserving a point of order, Mr. Chairman.
Point of order has been reserved, and the clerk will report the amendment.
Amendment to H.R. 115 offered by Mr. Richmond of Louisiana. Add at the end of the bill the following. Section 3, study on exonerations of persons convicted of capital crimes. Not later than 2 years after the date of enactment of this act.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This amendment would direct the Department of Justice to conduct a study on exonerations of inmates on death row and offer recommendations to reduce the number of wrongful convictions. The study would examine whether there are disparities among falsely convicted inmates based on race, religion, gender ID, or sexual orientation, and offer recommendations to reduce these disparities. The study would also examine the types of evidence that led to the exoneration to understand how we can improve the system and future prosecutions. According to one academic study published in 2014, 1.6% of death row inmates were exonerated between 1973 and 2004. Even more shocking, the study estimates that more than 4% of death row inmates are innocent. The sad truth is that wrongful convictions, like many of the other failing points of our criminal justice system, disproportionately affect minorities. This happens for many reasons, including the over-reliance on eyewitness identification, which studies have shown time and time again disproportionately hurts minorities charged with the crime. And we know that this aspect plays a role in death row cases because, according to the Innocence Project, 63% of death row inmates exonerated by DNA testing are African American. Despite the best efforts of everyone involved in the criminal justice system, wrongful convictions do still happen. When the price of a wrongful conviction is an innocent person spending years of their life behind bars, that's bad enough. When the price of an innocent person being killed by the government, that's unconscionable. For us not to try to learn from the past and improve the system, for us to do anything less than our best to make sure that an innocent person is not sentenced to death would be a failure of moral leadership. And for those reasons, I would ask my colleagues and the chairman to support this amendment on wrongful incarceration and the wrongful implementation and sentencing of the death penalty.
Would the gentleman yield?
Yes, I would yield the balance of my time to the ranking member.
I thank you very much. I support this amendment and getting a growing uncomfortable feeling that the strategies being used to preclude any votes on these very relevant amendments as not being germane is getting a little bit astounding to me. And so, Mr. Chairman, I ask unanimous consent to enter 3 letters into the record in opposition to the bill that is under discussion.
Without objection, they will be made a part of the record.
Yes, I just wanted to identify them, if I may. The NAACP Legal Defense Fund letter opposing the bill, the Leadership Conference on Civil and Human Rights, which has their own reasons for opposing the bill, and the American Civil Liberties Union, the ACLU, have theirs, and I thank the chair for allowing these to be entered into the record. And I yield back.
Does the gentleman from Ohio insist on his point of order?
Yes, Mr. Chairman, I do insist upon my point of order, and again, to save time, I will just state that it is not germane. This is a very narrowly crafted piece of legislation, and based upon the same argument before, I do insist on it.
Does the gentleman from Louisiana offering the amendment wish to speak on the point of order?
Yes. Mr. Chairman, I want to be crystal clear about what we're doing. We are expanding and increasing the likelihood that the death penalty will be used. The reports show that there's 4% of the people on death row are actually innocent. So we are increasing the likelihood that an innocent American citizen will be killed, and we don't want to look at why or how we can prevent that. If we don't pass this amendment and whatever blocks it, please consider yourself as a co-conspirator in the murder of an innocent American citizen. This is unconscionable that we can't get
First,
to
the gentleman from Ohio.
this point.
Mr. Chairman, I think the statement of the gentleman goes beyond the bounds of the rules in this committee.
The gentleman may want to reconsider his point, because it does go to the motive of members, and that is not appropriate.
No, I didn't say anything about the motives. And if someone is offended, then let them be offended. We're talking about an innocent...
Mr. Chairman, could we have the clerk read back the words of the gentleman, or whatever,
That's fine.
Whatever appropriate thing the chair thinks we should do? There's certain decorum that we're supposed to hold in this committee. And
I think rather than getting into a dispute about this, I would prefer to rule on the point of the order.
Well, I wasn't finished. And since something has been attributed to me that someone finds offensive,
well, but he
or indicating my
does find it
motives...
offensive because you said they should consider themselves a co-conspirator, which is impugning the motives of the individual in engaging in this debate in the Judiciary Committee. The chair is prepared to rule on the gentleman's request that the gentleman's words be taken down, unless the gentleman is either prepared to withdraw those words.
You can take the words down. You can do whatever you want. We're talking about killing innocent American citizens, and we're getting sensitive about the wording that I use?
The gentleman will suspend, and the clerk will report the words. All right. The gentleman,
The words were something along the lines of anybody that supports either this legislation or this point of order is a co-conspirator in murder.
Mr. Chairman. Mr. Chairman.
does the gentleman have, does the reporter have the ability?
Mr. Chairman.
Oh, I see. All right, so the gentleman from Ohio can describe the words that he finds.
The words I just said were my recollection of the words, not having a recorded device. I would encourage the gentleman from Louisiana, who I have great respect for, to continue with his debate, and is he willing to withdraw that particular segment that I just, my best recollection of what was said?
Would the gentleman yield?
I'd be happy to yield.
Thank you. I just want to point out that you can be a co-conspirator, in fact, without a negative motive. So one can construe the words.
Reclaiming my time,
The chair
isn't gonna do it.
prepared to rule on the motion of the gentleman from Ohio to take down the words of the gentleman from Louisiana, and he does not agree with the conclusion of the gentleman from New York. That is a clear impugning of the motives of another member of this committee. If the gentleman would withdraw...
Mr. Chairman, let me
Or
do my,
let me-
let me do my best to clarify
The gentleman may proceed.
what I was saying. And I think the gentleman from New York is absolutely right. If, in fact, the study is right that 4% of people who are on death row are innocent, if you follow it to its logical conclusion, if we execute 100 people, 4 will actually be innocent. And my comment was, if you prevent the amendment, you are in fact a co-conspirator. And wait, let me finish. You are in fact a co-conspirator in the death of 4 out of 100 Americans. It doesn't mean that that's your motive. Wait, let's be clear about what I'm saying.
Conspiracy, by its very nature, implies a motive. So,
No, it implies an action, and I practice criminal defense law.
Gentleman yield.
It implies the
Would the
action.
gentleman yield? Would Mr. The
Yes, I will yield.
Would you consider that describing a person as a co-participant
gentleman is
instead of a
not
co-conspirator?
recognized. The gentleman is not recognized. It is the ruling of the chair.
I'll strike the co-conspirator altogether.
The
You'll
gentleman
be an
has
innocent
withdrawn.
bystander while it happens.
All right, the
How's
gentleman
that?
has withdrawn. The chair is prepared to rule on the point of order. It's the opinion of the chair that the amendment is not germane. Are there further amendments to
Chairman.
H.R. 115?
Mr. Chairman,
What purpose does the gentleman from New York seek recognition?
in light of the importance of the subject and the narrowness of the ruling, I appeal the ruling of the chair.
Mr. Chairman,
What purpose does the gentleman from Wisconsin seek recognition?
I move to table the appeal.
The question is on the motion table. All those in favor say aye. Aye. Those opposed, no.
No.
In the chair, the ayes have it, and the motion is
Mr.
tabled.
Roll call vote, please.
Roll call vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Smith? Aye. Mr. Smith votes aye. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? No. Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? No. Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? No. Mr. Deutsch votes no. Mr. Gutierrez? Ms. Bass? Mr. Richmond? No. Mr. Richmond votes no. Mr. Jeffries? No. Mr. Jeffries votes no. Mr. Cicilline? No. Mr. Cicilline votes no. Mr. Swalwell? No. Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? No. Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? No. Mr. Schneider votes no.
The gentleman from Ohio.
Mr. Jordan votes yes.
The gentleman from South Carolina.
Mr. Gowdy votes yes.
Gentleman from Georgia.
Mr. Collins
Gentleman
votes
from
yes.
Texas.
Mr.
Gentlewoman from
Farenthold
Alabama.
votes yes. Ms. Roby votes aye.
Gentleman from Georgia.
Mr. Johnson votes no.
Clerk, has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 16 members voted aye, 15 members voted no.
And the motion is tabled.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Jackson Lee.
Amendment to H.R. 150.
Reserving a point of order, Mr. Chairman.
Point of order is reserved. The clerk will report.
Amendment to H.R. 115 offered by Ms. Jackson Lee of Texas. Page 2, line 1, strike the defendant and insert the following. Subject to subparagraph C, the defendant. Page 2.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
I thank the chairman. My colleagues, I think it is worthy of considering the concerns that have been expressed by members, but as well to acknowledge that no member is in any way covering or advocating for the dangerous acts of attacking our first responders or peace officers. But it is very clear that the challenges that come from death penalty cases, in some instances, delay justice for families. My amendment indicates, in considering the aggravating factors set forth in this paragraph, the court shall also consider the possibility of a sentence to a term of imprisonment for life without possibility of parole. And I believe in the discussions that have been had of the factors of innocence, the factors of discrimination, this should be considered appropriately. This bill would expand the number of federal cases eligible for the death penalty, nor would it would not expand the number of federal cases eligible for the death penalty, nor would it allow more cases to be prosecuted federally. Rather, it would expand the number of specifically enumerated aggravating factors. So therefore, knowing the difficulty of death penalty cases and the fact that federal prosecutors already have the tools they need to seek the death penalty in cases involving the killing of a state law enforcement, the idea of the life without parole in many instances brings justice to families more readily than following a line of the death penalty. The tools are already in place, and the difficulties with the death penalty already known. And I believe my amendment is a fair amendment that is germane, that should be considered in light of the fact that this is duplicative and that murder victims suffer with long-winded and long-extended penalty systems dealing with the challenges of the death penalty, and as well adding to the death penalty with more and more aggravated offenses when federal prosecutors already have the ability to bring justice for those who have suffered, really does not add to, I believe, the spirit of this committee and the fact that we are here for justice, not to hear ourselves be tough on crime. We're here for justice, and that is justice to the victims, and certainly justice to those who have fallen, and justice to the process that warrants the reflection on the difficulty of the implementing of the death penalty. I'd ask my colleagues to support the Jackson Lee Amendment. As I do that, let me take a personal privilege to acknowledge Jordan Wright, who's 9 years old, standing behind me in pink, in grade 5. She skipped 2 grades, very studious and passionate about government, has 2 brothers, and she is participating in Take Your Daughters to Work. And I see a beautiful picture here sitting in my office. And then Elena Goswami, 10 years old, 4th grade, River Oaks Elementary, attended the Girls Inc. camp, and she's here visiting, and she's considering the Peace Corps. Both of them are here visiting the Judiciary Committee. With that, I ask my colleagues to support the Jackson Lee Amendment, and I yield back.
Does the gentleman from Ohio insist on a point of order?
Mr. Chairman, we'll withdraw our point of order on this.
The chair recognizes himself in opposition to the amendment. This amendment offered by the gentlewoman from Texas seeks to amend H.R. 115 by including life without parole for the death penalty in this statute. I must oppose the amendment. The purpose of the underlying bill is to provide the same protections for state and local public safety officers as are currently provided to federal officers. In capital cases, federal juries can currently consider the killing of a federal law enforcement officer as an aggravating factor in determining whether the ultimate penalty is justified. It makes logical sense that state and local officers should receive the same protections. It does not make sense to include life without parole in this statute, since the statute lays out the aggravating factors for determining whether capital punishment is justified, and I believe the concern is misplaced, and in fact, may actually be creating a mandatory minimum sentence with the language that the gentlewoman has offered, and I know of her concern about mandatory minimum sentences. So I must oppose the amendment as offered by the gentlewoman, and I urge my colleagues to join me in doing so. The question is on the amendment offered by the gentlewoman from Texas. All those in favor, respond.
Mr. Chairman, excuse me.
What purpose the gentlewoman from Texas seek recognition? She's already spoken on the bill.
I understand. Could you get time so I can speak? Could you get time so I can speak? Just ask for time so I can answer.
Mr. Chairman, I'd like to be recognized, if I might.
Gentleman is recognized for 5 minutes.
And then I will yield to the gentlelady from Texas.
Thank you. By far, this is not a mandatory minimum, Mr. Chairman, and that is a buzzword to further undermine the idea that it is a alternative to the death penalty. It's not a mandatory minimum. It is the language is considering the aggregating factor set forth in this paragraph. The court shall also consider the possibility of a sentence to a term of imprisonment for life without possibility of parole. Mandatory minimum, the death sentence, is no end to that. So I disagree. My language is in considering and the possibility of, which is to suggest that there are more dangers fraught with the death penalty by adding another aggregating factor. And this is to counter the adding of another aggravating factor and to acknowledge the strong opposition that all of us would have on the killing of a first responder or a law enforcement officer. And I think this does not in any way be characterized as a mandatory minimum. And so I ask my colleagues to support the amendment.
Mr. Chairman. Mr. Chairman.
Does the gentleman from Maryland yield back?
I yield back, yes.
The gentleman from Texas.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I'll be brief. I appreciate my friend Ms. Jackson Lee's legislation, her amendment. But in the big scheme of things, what happens if we adopt this amendment? It regulates local and law enforcement officers to second-class law enforcement officers, that they aren't protected the same way that federal officers are protected under federal law. I think that is wrong. Our peace officers, whether they're working in Cut-and-Shoot, Texas as a deputy sheriff, or they're working for the FBI, federal law, when it comes to punishment of offenders against them, should apply equally and not treat local, state peace officers as second-class peace officers under law. I yield back.
Gentleman yield.
I've yielded back.
Okay.
Question occurs on, for purpose the gentleman from Tennessee seek recognition?
Thank you, Mr. Chair. This is a tough...
For what purpose does the gentleman from Tennessee seek recognition?
To strike the last word.
Gentleman's recognized for 5 minutes.
That was a test. Mr. Poe brings up a good issue, and I'm concerned about this because I was a police legal advisor, and I think when somebody targets a first responder, they're looking at people that are there to protect us, and that's wrong. But to say they're second class and they should be added here, mostly you can be added if you're involved in a federal task force, but does this make, right now if you're a high-ranking government public official, it includes federal officials. Does this make a governor a second-class official, wherefore if you shoot a governor or you shoot a mayor or you shoot a DA, that you're a second-class official? And if that's the case, should we include governors and mayors and DAs and stretch it to that? I mean, I'm just not sure. And I don't know that we should, but I don't know that we shouldn't. And, you know, Roy Cut-and-Shoot Harris would have been confused about this as well. You know Roy Cut-and-Shoot, don't you, Judge?
Yes, sir, I do.
Yes, sir, I thought you did. You're probably the only two people here that do. But, I don't know. And Judge, do you have any thought about that, about governors and mayors?
The gentleman will yield.
Please, yes.
I think under the legislation, we're dealing with peace officers, law enforcement officers, not other state government officials.
But we're trying to include them so they're not second-class citizens, and the bill, right now, the aggravating factors wouldn't include these other public officials if they're not federal, I think.
The bill deals with first responders.
If the gentleman yields back,
Yes.
or yields to me, we're only talking about law enforcement, first responders. We're not talking about governors and members of the state house. We're talking about...
I guess you're right, because it could be another bill. This bill, the principal bill deals with officials, but this amendment only deals with law enforcement.
That is correct.
So we'll yield, and I do remember the 12th round TKO in 1958, I think it was, and I yield back the balance of my time.
Question occurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye. Aye. Those opposed, no. No. In the opinion of the chair, the noes have it. The amendment is not agreed to. Are there further amendments to H.R. 115?
Mr. Chairman,
Who seeks recognition?
I do have an amendment, but I can,
The gentleman is recognized.
no, I was going to tell you I can just do it as striking the last word and comment on the
Gentleman is
bill.
recognized for 5 minutes.
Thank you, Mr. Chairman. I think that as we have traveled the country with the Community Policing Task Force, I think we've learned a lot about law enforcement and a lot about the fears and the danger that they face. And I just want to add in for the record that if we were serious about preventing the harm to our police officers that serve our communities, that we would focus more on the before-death action than the after the killing action. So when we start increasing the penalty, all we're doing is affecting what happens to the criminal afterwards. And when I practice criminal law, I promise you, not one defendant ever walked in my office and said, I committed this crime because the death penalty was not the punishment. In fact, most people who kill police officers don't care about the penalty. One, they never think they'll be caught, or two, they think they're going to die in the process anyway. So if we want to really protect our police officers, there are a couple things that I think we should be doing as a committee that we have heard from our law enforcement officers. Their go bags that they have should have better body armor in it that may prevent bullets coming out of long guns, which we have not banned, from going through their vest and then their body. We could limit the large capacity ammunition cartridges so that they're not outgunned, like the 2 police officers and the 1 sheriff in Baton Rouge in my district who were outgunned when they answered the call of a person walking down the street with a gun, or the long gun that had the ability to have a sniper picking off police officers in Dallas, Texas. So I just think that it's a commendable exercise that we're doing here, but I truly believe that it's an exercise in futility because it won't save a life. And I think that we can save police officers' lives by equipping them with better body armor. We can ban the most dangerous things. And, Mr. Chairman, if you remember this weekend, the officers and others testified about a domestic terrorist group that has killed more police officers than anyone else, and we have yet to have a hearing on it in Homeland Security or Judiciary, or talk about whether the feds are coordinating an effort to fight against this specific group who target and do not recognize the force of police officers. So I would just urge you, Mr. Chairman, that this will pass, but that we also get on to some things that will prevent the pain and the suffering of the families in the first place, so that we can prevent the unnecessary death of our people who have sworn to protect and serve our communities. And I think that as we have traveled the country, we have learned a number of ways in which we can do that. And I think that the committee would definitely benefit by having probably a classified briefing on the group that is the largest threat to our police officers and who have killed more police officers than anyone else in the country over the last couple years. I think that that would be very beneficial to preventing these atrocities from happening in the first place. And with that, Mr. Chairman, I'll yield back.